All right. Okay. All right. So aloha. My name is Molly, and I'm the case manager at Ikahi Mediation Center. Welcome to our Finding Solutions Growing Peace Brown Bag Lunch Series. Ikahi is a nonprofit community mediation center serving East Hawaii. We were founded in 1983 as a program of the Island of Hawaii YMCA, and in 2006 became our own independent nonprofit. We empower people to come together, to talk, and to listen, to explore options and to find their own best solutions. To achieve this mission, we offer mediation, facilitation, and training like this one to strengthen the ability of diverse individuals and groups to resolve interpersonal conflicts and community issues. Our Brown Bag Lunch series are held every Thursday at noon on Zoom. You have to register on Eventbrite each time to receive the Zoom link. Our next speaker is on March 16th is Marina Piskolish on the topic, The Power of the Pause, a practical tool for conflict resolvers. And I will put in the chat the Zoom link for it. So 1 minute, please. Maybe I won't do that right now. And so here are the other events that we have coming up. We have free in-person training called Conscious Commerce with Sylvia Delina on Thursday and Friday, March 9th and 10th from 8:30 a.m. to 4:30 p.m. at UH Hilo. In today's world, entrepreneurs need to be aware of local and global environmental issues. How can you retool or re-envision a business in our post-pandemic world? Learn a process to go from idea to business plan for small business startups or businesses that must reinvent themselves for a new economy. And I will include the link in a little while in the chat box. And then next is our basic mediation training, which starts February 24th. This 4-day interactive training is perfect for anyone who wants to communicate more effectively, personally, and professionally, become a better negotiator and problem solver, and increase your value in the workplace. Whether you want to enhance your communication skills or become a volunteer mediator at Ikahi, this training gives the tools you need to start resolving conflict in a peaceful, lasting way. And again, I will include the link shortly. At the end of the talk, we'll ask you to fill out a short survey, which helps our grant funding for this free series. When I put the survey link in the chat, please take a moment to give us your thoughts. We'll also send an email later with slides and a video link. So without further ado, let me introduce our topic and speaker. An attorney's view of conflict resolution, what lawyers think and care about in mediation. Lincoln Ashida is a director at Torkelson Katz, a law corporation practicing in the areas of business, corporate, and labor employment law. He is County of Hawaii's longest serving corporate counsel, 2000 to 2014, and is a county deputy prosecuting attorney. A graduate of Hilo High, University of Michigan, and Creighton University School of Law, Lincoln is an instructor in political science and administrative justice at the University of Hawaii at Hilo. So you can take it away, Lincoln. Thank you so much.
Hey, good morning. Aloha mai, everyone. Thank you for joining this Brown Bag Lunch series. Molly mentioned my great part-time gig as an instructor at UH Hilo, and my favorite student, Missy Miyashiro, is on this Zoom. So how good is that? Oh, that was a long time ago, eh, Missy?
Not that so long ago.
Okay. Well, anyway, thank you all for being here. In terms of format today, if you have any questions about what we're talking about, by all means, don't wait till the end. Just go ahead. And I'm not even a proponent of the chat box because I always forget to look at the chat box. So either you can do the raise hand thing, but that's no guarantee either. So I'm all for doing exactly what we say not to do in mediation, which is just talk over people and say, hey, could you hold on? I got a question, and that's fine, okay? Because we want to be as interactive and responsive as possible. So to start off, I'm going to go share screen. Okay. And let's see if I do this correctly. Did that work? You see my slideshow, is it there? Can you see it? Is it on there? Thumbs up. Okay, great. So we're going to start off with answering the question, which I think every single person on this presentation today knows the answer to, and that is, what is mediation? Of course, mediation is a process wherein the parties meet with a mutually selected, impartial, and neutral person who assists them in the negotiation of their differences. Now, why is it so important that I put this slide first? Because today's presentation really is looking at it from, not necessarily from a lawyer's perspective, but we're going to be talking a lot about lawyers today and what they think and how they approach mediation. And what, as a threshold matter, what really concerns me a lot is how many lawyers really don't understand this, okay? Mediation is not an extension of the courtroom, okay? It's not your opportunity to go to ikahi where there's probably non-lawyers there and bully your way through things, okay? I think that for lawyers to meaningfully participate and be a part of mediation, they need to understand that, among other things, mediation is a process that assists them in negotiating differences, okay? It's not arguing differences. It's not a mediator who's going to act like a judge there, but should be an interactive and, to some extent, a collaborative process. So what is the purpose of mediation? Again, to clear up misunderstandings, determine underlying interests and concerns, find areas of agreement, and incorporate those areas into solutions devised by parties themselves. Why do lawyers have a hard time sometimes in mediation? I'll tell you this because I've been a trial lawyer most of my career. And, there's a lot of different sayings about trial lawyers. And one of them is this. It says, the legal scholars out there say, if you're a litigator, if you're a trial lawyer, you try your case. The day you try your client's case, you lose. You ignore your client's case, you try your case. And that is like the trial attorney's mantra, where you can see where that's not necessarily consistent with some of the processes and goals of mediation. Part of a positive process of mediation is being able to not only understand, but see things from the other person's point of view, okay? Understand that there could be very often there are some misunderstandings and working towards a solution. It's not my way or the highway. So what are the benefits of mediation? And again, this is from a lawyer's perspective, things that need to be communicated to a client in order to have a meaningful and hopefully productive and successful mediation. Number one is to let the client know and have them understand that it is the parties that are in control, okay? In other words, we're going to a place, a mediation, where there's not someone sitting on a high bench with a black muumuu, the judge saying that this is what they are going to decide. That mediation is the process where you can really, you as a party, an interested party, someone who has some skin in the game, who cares about what happened and what may happen, that you will have a direct hand in controlling the outcome. And I cannot emphasize this enough, because a lot of times that's what we see in terms of our clients feeling the most helpless in. Sometimes when they're in a case, whether, especially when they have been sued, okay, they very much feel a sense of loss of control. So that's one of the positive aspects of encouraging mediation, is that you can let them know that they will have a certain degree of control. This is big for this. Let's face it, this is big for everybody, okay? Limit fees and costs, okay? Because for the most part, lawyers, unless you're on a contingency, which is rare for cases that go to mediation, win, lose, or draw, you get paid, or at least you bill for your time and your effort. So mediation is an excellent way that limits fees, attorneys' fees and costs. The cost of litigation is today is, I think, sometimes out of control. And so this should be a consideration for all clients, whether you have means or you do not have means. Ensure privacy. this is something that I think a lot of clients maybe don't think about, but with mediation, you not only is the mediation process private and confidential, but you can also control the outcome in terms of a settlement agreement that will be, the parties will hold as confidential. Now, if you go to court, all bets are off, right? Because in America, by our Constitution, you have the right to a public trial. So all of the things, including your dirty laundry, run the risk of being on parade and display if you go the litigation route. So for clients that have things in their case or controversy that may not be necessarily very favorable to them or cast a negative light on them, this can be a very, very important consideration for them. Finality. Most cases, the vast majority, I would say if not all cases that come to mediation at ikahi, for example, are civil disputes, okay? And I've been practicing for a long time, and I have cases that are currently on appeal with the Hawaii Supreme Court and their Intermediate Court of Appeals, which have been up there for years with no indication that they will be decided anytime soon. And there's a lot of reasons for that. And the principal reason is that there are more cases filed in Hawaii than there is capacity for our courts at any level, whether it be the trial or appellate level, to handle. And this is true both at the trial level and certainly at the appellate level. The criminal cases are going to take precedent because of the constitutional speedy trial rights. And the Supreme Court has held that speedy trial rights under the Fifth Amendment also apply to appeals. So more likely than not, our Supreme Court or Intermediate Court of Appeals will hear criminal cases before our civil cases. So there really is truth to that old adage that goes, justice delayed is justice denied. So one of the appealing things, and all of this should be explained by lawyers to their client, is that mediation is a vehicle or a means by which you can achieve finality much sooner than later. And that finality, if there is an agreement, may involve or include a provision that as part of finality, there will be no appeal. Excuse me, foster good relationships. Come on, man, we live in Hawaii, right? It's the Pono thing to do, right? Sometimes you hear lawyers in mediation, and when they're prepping their client, they say, you know what, you don't have to like the guy, okay? You don't have to get along with him. We just want to make an agreement. And I kind of cringe when I hear that, because that is not, to me, conducive to a process where you try to come to an agreement, okay? And when you come out and say stuff like that, well, you don't have to like them, there's better ways to say that, you should encourage more on the positive aspect, like, that, we need to be, everybody should be respectful. Let's be respectful, and, I think that this is something that, again, lawyers say things like that only because, they're trying to convince their client that why mediation is a good thing, but, or why they should settle the case. But, in that process, I urge lawyers out there, pay attention to your words, because words can be very powerful. Yeah. So you should always work towards or say words that promote more of a facilitative and collegial process and hopeful resolution. Evaluating whether a case is right for mediation. Nothing wrong with recognizing that some cases are just not right or appropriate for mediation, okay? And I think that for lawyers, that's very important that they recognize that, because they are dealing with people's lives. And I guess the most obvious example of this, and why I put this on the slide and I'm not really going to talk about it or belabor it much, is, I spent a significant amount of my legal career as a prosecutor. And I prosecuted a number of significant violent crime in this, in Hawaii. And you need to recognize that there are some cases that mediation may not necessarily be the proper vehicle. So enough said. So when you do the evaluation for the vast majority of cases that are right for mediation, the first thing that I think lawyers need to do is to evaluate whether a mediated agreement is or may be in the best interests of their client. Now, the reason that the principal reason that this is important is because as a lawyer, we are guided, and we are, well, not only guided, we are basically under the control of the Supreme Court's Hawaii Rules of Professional Conduct regarding lawyers. And our job, our duty, our requirement of our job is to zealously represent our client to the best of our ability and always look out for their best interest. Okay, so for lawyers, this is a very important consideration. So if the answer to this question is yes, a mediated agreement is in the client's best interest, and it could be for a variety of reasons. It could be because of the things that we said in the previous slide, like finality, some more expeditious closure of the matter, privacy issues. Okay, maybe the client doesn't have money, okay, and it is a cost issue. These are all considerations that lawyers need to consider when evaluating a case and whether, in fact, a mediated agreement may be in a client's best interest. Okay. The other thing that lawyers must do when they evaluate the case and talk with their clients, right, is they need to explain to their clients what the risks are, on both sides. Okay, and I have not really come across a case or that many cases in my career where, if it's being litigated, there is not both sides or opposite sides or another side or another version. Okay, and sometimes what lawyers end up doing and is, in order to curry confidence of their clients in them, when they meet with their clients, they talk about all the things that they're going to do in court and all of the things they're going to do with this case and how skilled they are and how experienced they are and how they're going to get this result. And, that happens, but I think that's somewhat irresponsible if you do not also tell your client and explain to your client what lurks on the other side or what's possible. I often tell clients this, my job is to tell you what will happen on your worst day. Okay. And, for the most part, that's very much appreciated by clients. I mean, you don't start off with this, obviously, with the doom and gloom, but it is your responsibility and it is incumbent upon you as an attorney to tell a client and let a client know what is out there within the realm of or scope of possibility of bad things that could happen or negative things or bad facts that they have in their case. All right. And also this is part of managing clients' expectations. Okay. When clients come to us, sometimes they feel like they pay a lot of money and they, you spent the time listening to them and they want you to do, they have an objective in mind. Okay. They really have no idea what the process is like, but they come to you and hire you because they have an objective in mind. And normally that objective is getting what they want and winning. All right. And you as an attorney cannot stoke that flame. I mean, yes, there's confidence in your ability. Okay. But you need to really level with clients and explain to them not only what could happen on your worst day, but even when you have a good day, you may walk away from this feeling that, wow, I didn't get everything I wanted. And maybe life is not fair. And if you think that way, fine. But the reality is, whether it is and this can happen not only in mediation, right? Because you've all heard this, a lot of you are mediators. A lot of people say, well, mediation is like successful if everybody walks away not completely happy, but they can live with it. You've heard that before, right? That's also true in court. I've had a lot of cases, both when I was a prosecutor, when I was corp counsel, and certainly now in private practice. Even when you win, the client sometimes feels like they lost a little bit, not whole. And that's not just because they got to pay my exorbitant fees. It's because maybe they didn't get everything they wanted in court, or, when they have buyer's remorse, or, after they think about it for a day or two, like, it's not all that. And that's a big part of what we lawyers need to do better, is really managing the expectations of the client. Again, not coming off as it's all doom and gloom, but having the sense of explaining to clients the realities of the justice system. Okay, that makes sense. Okay. So how do we prepare? We talked a little bit of how we prepare clients for mediation. How do we do it? First of all, you as a lawyer, and this is directed to the lawyers, these slides, you better believe in mediation. Not just give lip service to it, not participate in mediation because the judge ordered it. Okay. Not say things to your client like, well, you know what, the judge ordered it, so let's just show up, and it's our opportunity to get a free peek at what their argument is going to be on the other side when we eventually get to court. Okay. Lawyers say that a lot, and they do that in order to get their clients to agree to mediation or show up or pay, because a lawyer is going to charge the same fee per hour showing up in mediation as they do in court. Okay, unless you have a separate fee schedule, but most lawyers don't. All right. So to get the client there, that's oftentimes what we hear. I think that fosters and creates a more negative attitude towards mediation. And I think you fail as an attorney, okay, by going down that road. Okay, you, in order to meaningfully participate in mediation, and that is an ethical requirement, by the way, according to our rules, you need to believe. You really need to believe. Okay. Also, in managing expectations, sometimes explaining to a client and having them understand that the victory lies in reaching an agreement. Now, there's a number of reasons for this. We talked about some of those reasons in terms of a quicker finality to the case, rather than having it languish for 3 or 5 years. Okay, limiting costs, the privacy considerations, the confidentiality considerations. These are the things that, as a lawyer, we need to spend the time explaining to the client the benefits of these things that can be achieved, sometimes only when there is a settlement agreement that in court, that is a result of a mediated settlement in mediation, right? A lawyer must explain the process and what the client may expect. Now, this is something that is true in a lot of things that lawyers do, because we go to court all the time. We've been doing this for so long. It's almost like we forget that for a lot of times our clients, this is the first time they've been exposed to the criminal justice system as a participant, as a litigant, as a party, where they don't know what to expect. In the case of mediation, they don't know what to expect. It's even things like what to wear, how to dress. Do I have to bring my, are we going to have a lunch break? Because some of them may have dietary or other health concerns, where they need to eat or drink. Something as basic as that, as well as, okay, where are we meeting? Okay, where is this? Is there going to be secure? If you're meeting at the courthouse, one of the rooms there, there's TSA security that you have to go through. Okay, who else is going to be there? Is the judge going to be there? Is the other person or persons going to be there? You really need to spend the time explaining this. And part of this, I find to be most effective, especially when it's so foreign to clients that you have who may not have this experience, is you need to understand how they learn, right? And we all know that we all learn differently, right? Whether we're auditory, visual, learn by doing. So what I do to make sure all bases are covered is I talk to the client, I explain it, but then I also follow up with an email explaining what we just talked about in case they're visual. And I find that really provides them a sense of security and comfort, knowing that what to expect when they first get there and going in. Excuse me. Again, I think this is the broken record part, but you really need to manage expectations, right? If we've heard a lot of cases where lawyers, and I know this happens, show up at ikahi and they end up walking out within the first 20 minutes because they say, okay, you're not willing to budge, then no sense we be here. It's over. And they walk out, and there's a variety of reasons that may happen. But again, if you believe in and trust in the mediation process, part of this is explaining to your client and managing their expectations. Okay. And again, it doesn't have to be doom and gloom, but it has to be preparing them and having them understand and believe in the process. Okay. And not just believing or thinking about what the end looks like, the end settlement looks like, but also having them understand the importance of the process. Right? Let the client vent before. This is so important. Okay. Sometimes you have these cases, mediators, and you've seen them come in, and it's like all those months or years of animosity, boy, it just comes out of that pressure cooker in that conference room in the Lagoon Center, right? Okay. And the way we deal, you as a lawyer, the way you need to deal with this is you got to have your client the day before, whenever at your office, you just let them vent. You just let them, and you prepare them and tell them, it's not going to help anything when you see so-and-so tomorrow, if you start going off. So tell you what, go off on me right now, And I think that's so important because, again, this is all part and parcel of the preparation, managing expectations, but this is how you really can help your client. Okay, so in terms of the mediation process, this is again preparing your client, but you need to know ahead of time how does this mediator conduct the mediation. Now, ikahi, pretty much the ikahi mediators, they follow the same routine, but there are mediators, private mediators, and I do a lot of mediations with DPR mediators. They have different styles. I did a mediation a couple months ago where the parties, my client and the opposing client, never saw each other the whole day. They were in separate rooms the whole day, and the mediator just bounced back and forth. A lot of mediators, and this is probably what you're more familiar with, start off the session at the beginning and end the session at the end of the day with everybody in the same room, hearing the same thing, right? Well, just understand that not everybody does that, okay? So a big part of preparation is understanding who your mediator is, what their style is like. And then there's no harm in calling them ahead of time and saying, hey, I just want to know what, what the process is going to be tomorrow so I can prepare my client. And you should get that information. Okay. This is so big. This is so big. Okay. My former student, Missy here, knows that one of my life mottos is, I never met a microphone I didn't like. Okay. But sometimes in mediation as a lawyer, you gotta exercise restraint and you gotta just shut up. Okay. And there's nothing more important than empowering your clients to be the one to speak. How many times have you seen this, mediators? When you have a lawyer in mediation, right? When you come back and you talk, the lawyer does all the advocacy. And then the lawyer tells you, the mediator, okay, we will offer $1,500. See what they say. And the lawyer does all the talking. Client's just sitting there. Okay. It should be the opposite way. Okay. There's a certain benefit to the empowerment if lawyers give their client not just the permission to be the one speaking, but to be the ones making that offer, that concession, or expressing that concern. Okay. I think the best lawyers in mediations are the ones who prepare their clients, whether it be even during the mediation, you can have the private, you're going to have a lot of time, especially if you're in that way, you're in your room by yourself with your client and the mediators with the other side. Okay. Empowering your client to be the one speaking. Okay. I think there's a tremendous value to that. Right. Game face, lawyers always believe game face, go to court, game face, and that's fine, right? But in mediation, smile, say good morning, okay? It ain't war, okay? It ain't war, and don't go in there. This is especially so when you have a client and the other side's not represented by an attorney. Don't go in there and be bully lawyer, man or woman, okay? Because I think that's reprehensible, okay? One of my life mottos is be nice to everyone all of the time, okay? And you can still be an effective advocate. And this is true even in court. You can be a very effective, very good advocate. Doesn't mean you have to be mean, okay? You can be nice. Matter of fact, sometimes you're even a better advocate when you are very nice, all right? Now we turn to some ethical considerations for lawyers. Lawyers are required under rules of professional conduct to zealously advocate for their clients, okay? Now, sometimes, understandably, this can be problematic. It can be problematic because you have situations where clients tell the lawyer, this is what I want. And so long as what they tell you they want is not illegal or unethical, you need to do it. Okay, you need to do it. Or you need to get out of the case. Or hopefully, within the context of mediation, and this is normally when you trying to get your client to agree to mediation, why it's a good thing. Or worse yet, if you're in a situation where the judge has ordered mediation, okay, lawyers shouldn't be cowards and say, you know what, we got to go mediation, not because I want to, but because the judge said we have to. Yeah, that's a cop-out. That's a big-time cop-out, okay? But lawyers still need to be aware of this, okay? We need to advocate on behalf of our clients. That's true. But at the same time, we really need to spend the time working with them because sometimes, and I don't want to sound flippant about this, but sometimes clients don't understand or see what really is in their best interest. And I think we need to spend the time sometimes helping them get to that point where they do see it. Okay.
Hey, Lincoln,
Yeah, go ahead.
there's a question in the chat box.
Yeah,
Someone
okay.
wants to know, some clients want the lawyer to speak for them. How do mediators handle that?
I don't know. Mediators, how do you guys handle that? since I'm the hired gun here, right?
Aloha, this is Susan Bambara. I've had that experience. Both, I've mediated with a lawyer at ikahi who was exactly that. And it ended very quickly because the other party wasn't happy. They thought they'd get to be heard and hear the other side and do mediation. I've also had the pleasure of mediating with Lincoln, and he just you could tell he looked at his client and he kept the client strong. Both sides were heard and we came to an agreement.
Well, thank you for that. Appreciate that. Yeah, so I think the short answer is it's really up to the mediator, because the mediator, you know, I think you need to be in control, you know, and you know, I know it's a facilitative process. You're the neutral, but I mean, I think that's why we're having this session today, right? Is we want to make sure that the mediation process is a positive process. And you know, this next bullet, this is why it's critically important to get sincere buy-in from your client. Okay. And I tell you what, you're not going to get buy-in when you tell them the stuff, like I said earlier, about, we're just going to show up because the judge said we gotta, and we get a little sneak peek at their case. And we don't have to come to an agreement. You don't have to agree to anything. Okay. I don't know if that's the recipe for success. Okay. I mean, you need to be honest with the client and say, yeah, there's a possibility that we may not come to an agreement. And, you know, maybe that's not all due to our side. Maybe that's due to the other side. That's always possible. And actually that happens. But again, it's an earnest, sincere effort to, and buy-in is such a terrible word. When I look at it now, I did this outline, maybe that's not the right word, but you know, having a sincere belief in the process and willingness and desire to go through this process. I think that's the sweet spot where you want to get your client to. Your client should be making the offers of concessions, not the lawyer. I talked about this last slide, right? If it's possible, your client should be the one talking. Encourage your client to be the one to talk. I think it's important for two reasons. One, I think it's very therapeutic for them. And number two, I think it empowers them a lot that, you know, that they are involved in the process. You know, enough said on that. Lawyers can effectively advocate through facilitation. This is important for lawyers, this slide and this bullet, because sometimes lawyers misunderstand this and think, I'm paid to be an advocate. I got to argue, okay? Sometimes the best skill that lawyers have is effective advocacy through facilitation, okay? And that obviously takes some practice and experience, you know, but again, when you are able to do that on behalf of your client, I think you really hit that sweet spot and you are really, really serving your client. And at that point, you are really worth your, you know, what you're being paid. Okay. And understanding this, that a mediated, you know, sometimes, and again, this is managing client expectations, because, you know, they don't know what to expect. They don't know what mediation is or what's going to happen after or what happens when we come to an agreement. And sometimes a misnomer out there is, well, it's only mediation. So therefore, anybody can change their mind and walk away later. Okay. And that's not necessarily true, because if you have a mediation that is you're engaging in, that is part of a active court case, civil case, that mediated settlement that you come to, that the mediators type up in their conference room at ikahi, you know, that will be, can be, and often will be reduced to the judgment, the settlement agreement, or a formal settlement agreement that may result in more than likely a dismissal of the court case or entry of judgment for one party under certain conditions, stipulated conditions. So again, this is a way to impress upon the client that there's no such thing as it's just mediation, and an agreement is just hollow because anybody can walk away from it. That is not necessarily true. Oftentimes it is memorialized somehow in a formal settlement agreement and dismissal or judgment. So we've reached the mahalo slide, everyone. And we did that in 43 minutes. So I'm going to stop the show or stop sharing so I can see the chat and all the stuff people are saying about me. Okay. Does anyone have any questions or any comments? I love your comments.
I have a question. So I'm an
Yeah.
apprentice mediator. And so
Yes.
I've gone through the process of, typing up the agreements, but I'm not a lawyer. I have no idea. I've never been to court. What happens to the agreement once it gets to the civil court?
Well, I've had in the case of settlement agreements that are crafted right on the spot, I've seen it happen. One or two things. There could be many possibilities, but primarily one or two things. Sometimes, that is just an agreement that's written out and signed that day. I think a lot to impress upon the parties involved the importance of what occurred and that it is an agreement. Okay, I get that is a big psychological thing. I think it also helps ikahi when they write for their grants and their funding that they were able to come to agreements. But I'll leave that to Julie, Molly, and company. Okay. But also, Susan, I've had cases where that actual agreement written out by a non-lawyer mediator is actually used as the formal settlement agreement to resolve a case. Okay, so never underestimate the importance of that. Okay, and never say, "Well, I'm not a lawyer." Although for a lot of people, that's because they want people to know they're not lawyers, because lawyers are so a-holes sometimes. But but you can do it. I mean, some of our mediators, they have, the other thing too is this. I go to the Bar Association functions, and there was a time when I was the youngest lawyer in Hilo. Can you imagine that? Holy cow. Okay. And of course, we had outhouses and candles in the house at night. Okay. But I go to the Bar Association now, and there's a lot of youngins out there. And I'm willing to bet if a lot of those did mediation, many of you mediators have way more experience than them. Is that my friend Elizabeth Kent down there? Oh my
Hi,
God.
Lincoln.
Elizabeth Kent. Oh my God. We can do a brown bag on her, Molly.
Yep.
What a
This
fabulous
was wonderful,
facilitator.
Lincoln.
What a fabulous facilitator Elizabeth is.
Thank you. But I really enjoyed hearing your remarks. And I guess can I add in one thing to end?
Sure.
I'd have a little different answer to that question, because I tell the parties, this is a contract you're entering into. And so you can't, there's lots of things that you might put into a mediation agreement that couldn't be enforced in court, like, hey, use a nice tone of voice. You can't enforce that.
Right.
But if you say you're going to pay somebody
That's right.
$50 by Friday at 4:00 on February the 17th, you better pay that. Otherwise, that's a contract. That's what I think of, how I think of those agreements. So to me, the written agreements are really important.
Excellent point.
And I loved all your points, Lincoln. Thank you.
Thank you, Elizabeth. Elizabeth is one of those mediators who is recommended by retired and former judges. Okay, that's a kind of credibility, street cred she brings. So, and that's actually how we met. So anyway, any other questions or comments or thoughts?
Lincoln, how important do you think it is that attorneys come with their clients to mediation?
You know, it can go both ways. Often there've been cases where I just prepare the client for mediation because and a lot of it is an assessment of who's on the other side, especially if the other side is not coming with a lawyer. You don't want that imbalance, you know, because then, you know, let's face it, a lot of times when people, you know, they don't have a lawyer and the other side has a lawyer, they feel they got a lawyer up, or they feel that they gotta, you know, they're not being going to get a fair shake. Okay, so there are a lot of times when I just prep and you know, I'm contacted by ikahi and of the DPR mediations, that's all lawyers. But for, you know, community-based mediations like ikahi, oftentimes I just prep the client and say, look, you know, this is how it's going to be. It's better you go by yourself. Okay. But also check this out. There's also danger when both sides bring lawyers, because then the lawyers end up fighting and then the whole thing blows up, goes sideways, and you're out of there in 15 minutes, you know? So, and a lot has to do with the personalities. You know, I think most of you mediators, especially those of you who've been around so long, you know that. You know, there's certain lawyers out there who, oh, we got a shot. Others think, well, you know, I guess I'll be going to Cafe 100 before 10 o'clock this morning. We're getting out of here soon, you know? So it all depends. Every case is different. It all depends. But I think preparation, paying attention to the dynamic of who, you know, who's involved. Every case can be different. It's my opinion. By the way, I'll qualify everything I say today by, this is just my opinion. Okay. It's not, you know, it's not the way to do it. Okay. It's just based on my personal, professional experience. Okay. There may be other ways to do it, or, you know, and that's fine.
So Marianne Loughlin has a question for you.
Okay.
She says, Mr. Ashida, your comments were directed more towards what an attorney should do to prepare their clients for mediation. But what would you mind sharing what lawyers look for and or appreciate from mediators, and possibly share some examples?
Okay. I think that there's a big difference between selection of a mediator within the DPR context and within the community-based mediation context. Okay. Let's face it, for us lawyers, and there are probably lawyers out here besides Elizabeth on this Zoom, when you're dealing with the DPR mediators, a lot of time the selection that lawyers make are based upon factors like what type of case do I have? And is this mediator tending to be more favorable towards a contractor or a homeowner if it's a construction defect case, you know, or how do I get along with this? A lot of the DPR mediators are retired judges. Oh, I enjoyed appearing before this judge, and I always felt I got the benefit of the doubt, so I like this judge as a mediator. Okay, that happens, and that's life, right? That happens. But for like in ikahi, what we look for is, and this is again just for me personally, I like what I call strong and decisive mediators. I love mediators who take control, but not in an aggressive or overbearing way. But you do it in a way, and maybe it's what I said earlier in the other smile, just you do it with a smile, but it's clear that you are in control, even if the parties are in control with respect to coming to an agreement or not. You as a mediator are there to facilitate, and I hate the word control, but I can't think of another word. You are controlling the process, how it's going to be. And of course, you know, the other thing people say, oh, I like somebody who's fair. Yeah, but who's not, right? You all serve because you're good people and you are fair, right? And you know, interestingly, and I'd like to hear what maybe some of the other lawyers or advocates on this call may have to say, but I really appreciate a mediator who, yeah, you know, you're there to facilitate, you hear both sides, but I don't mind hearing what you think about the case. And sometimes that can be very, very helpful in reaching settlement. So I not only invite that, I actually like that.
Aloha from Canada.
Hi.
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 Thank you so much for this talk. It's been very insightful. I just want to make two comments. The first one about, I'm a mediator. I do family and I do child protection mediation. And the comment about life isn't fair. One thing I love about mediation is we get to talk about that. You know what? Life isn't fair. But I think through a lot of my mediations, people get to hear each other's sides and then actually understand why someone's doing something, as opposed to just going to the court process where they don't get a chance to say what's actually bothering them, right? So that's one thing. And the other thing I wanted to say is when I'm in a mediation, and I love having the lawyers there, if I find the lawyer talking more than the client's talking, and I've heard the client say, well, I don't actually want 50-50 parenting, I just want some more parenting time than I have, for example. And the lawyer is pushing, nope, we want 50% or nothing. I will do caucus, right, and take a break. And I will talk to the lawyers or the people and say, okay, what's going on? And kind of ask that. So it's okay to stop the mediation process and take a wee break.
You know, Lana,
That's
I
all.
like that. I like that.
Thank you.
I'd love that. Yeah, that's what I meant about the mediator who remains in control. You know, doesn't have to be overbearing, but I like that. I just love that.
All right, do we have any more questions or comments for Lincoln? I don't see any. This has been a wonderful presentation. Thank you so much, Lincoln. I mean, this has been wonderfully helpful to me for sure as a mediator. And just, I want to thank everyone for coming today. If you could please take a few minutes to fill out our survey online, which helps with our grant funding for this series. The link is in the chat, and check your emails in the upcoming days for the slides and the video link. And we'll see you folks next month. Thank you again.
Thank you, everyone. Thank you for being here. Enjoy the rest of your day and have a wonderful rest of the week and weekend.
You too. Thank
Bye-bye.
you.
Bye.
Bye, everyone.
Aloha. Thank you for your facilitation.